LLC and Haddad versus G&G Capital LLC, docket number 21-273CB. And as we go forward here, as I was connecting everybody, there was someone talking on the phone, having a separate conversation. We are now on the record in the courtroom, so actually, if you don't have a speaking role, the proper Zoom etiquette is to mute yourself until you're ready to speak, and then to unmute yourself. That also helps with background noise so that it doesn't interfere. And if you would do that, I would appreciate that. And this is the time set for a hearing on show cause why a preliminary injunction should not be granted. There is also the defendant's motion to dissolve the TRO. And I would mention at the outset that defendant also has a motion for summary disposition under MCR 2.116C 5, 8, and 10. This summary disposition has 7 days notice. The motions under 2.116 require 21 days notice. I will not hear a motion for summary disposition today. But I will hear the show cause and the motion to dissolve the TRO. We'll start with appearances for the plaintiff, please.
James, hopefully you can hear me. James R. Giddings on behalf of the plaintiffs in this matter, 1618 South Washington LLC and Anthony Haddad.
Good afternoon, Your Honor.
That was you, Mr. Albright?
Was I heard?
Yeah, you were heard. Mr. Albright?
I'm sorry, I didn't mean to talk over Mr. Giddings. I thought he was done. My appearance for the record, Your Honor, I am H. Kirby Albright. I'm appearing for and on behalf as co-counsel for G&G Capital and Vincent Genealogy, who are two of the three named defendants.
All right, any other appearances?
Yes, Your Honor, James Happy is co-counsel for G&G and Mr. Gentilozzi also. I have a non-speaking role, so I'll probably stay on mute most of the time. If you have any questions, feel free to ask.
Thank you. Okay, then that will take us to you, Mr. Giddings.
Good afternoon, Your Honor. I hope things are well. I'm not going to be very lengthy here, but I am going to refer to a couple of points of law. I mean, first off, of course, the injunctions are to maintain status quo. Most of this is covered in my brief, but I want to just remind everyone of State Road Bridge Co. v. Saginaw Circuit Judge, where it said the usual office of an injunction is to preserve the status quo of property until the final hearing on the merits. There is a serious dispute about the ownership and possession of this particular piece of property. As shown in his affidavit from Tony Haddad, he's been in possession since 2018, September of 2018, and he bought this under a land contract. I am not unmindful that this land contract is disputed by Vincent Genealozi, and they've labeled the signature on there as a forgery. That, of course, is not what Brandon Davis said. That was, he did not sign the document. And there is a brief affidavit as a part of this file. I think it's important to keep in mind, however, that in Mr. Davis's affidavit, there is not one word about not having entered into a contract with Haddad. He doesn't disclaim that, and he says nothing about any possible terms. And of course, what we attached, and hopefully the court got a chance to look at it, they're not the clearest, but a series of text messages from Brandon Davis to our client in which he references the contract and the receipt of thousands of dollars over a period of time. And of course, in writing or not, Michigan law is crystal clear that part performance is an exception to the statute of fraud. So you can have a contract And one of the cases I was going to mention today is one called Zach v. Gray, which holds to that effect. It's a 1949 Michigan Supreme Court case. But Haddad's affidavit talks about the amounts of money he put into this, thousands of dollars worth of improvements, and that Gentilozzi was on the premises. Gentilozzi well knew, because he had him kicked out, tried to have him kicked out, about his physical presence there. And he even came to, according to Haddad, this may be disputed, but he came to Haddad and said, I'll find a buyer for you. And none of that has been disputed under oath by Mr. Gentilozzi. I mean, those facts, for purposes of our motion here and the request for injunction, are essentially without any dispute. And so our guy got a contract, paid money, valuable money, and it's an arrangement of which he says under oath that Gentilozzi was well aware. Now, Gentilozzi relies on a deed. Well, the law is pretty crystal clear there as well. You can't just have a deed. We are entitled to show that he was not a BFP and he didn't pay value for this. And of course, he's not a BFP because by affidavit and by the proofs we've submitted here, he knew about the interest of Tony Haddad and his value, quote unquote, that he paid for it. He did pay some money toward recording fees and paying a back contract, but the debt, quote unquote, that was used to discharge the amount due to Brandon Davis was a gambling debt. And we will show that before this is all over. And if it wasn't, of course, Mr. Gentilozzi can come forward and say it, but I think I'm pretty confident that we'll prove that this was the debt was to discharge a gambling debt, violation of state law. I cited the statute. You cannot do it. It's not a valuable consideration. And that statute says his recording is good against any subsequent purchaser in good faith and for valuable consideration. Well, he is not a good faith purchaser and didn't pay valuable consideration. Going back to the status quo, if this injunction is denied, the defendant has been clear. They're either going to sell this property or enter into some lease. And that is, we submit not only in violation of our rights, but upsets the status quo, creates a situation in which we'll be forced now to complicate this litigation by joining that potential purchaser, lessee, and tussle with them over BFP rights, notice, and who the owner is. So that's one of the reasons why in that case I first cited, it's imperative, really, it's important for this court to let the dust settle. Let's find out where all the pieces are and get people in and let them testify. And in that regard, one of the important people is Brandon Davis, and we have served him. He's in default. We filed our default. We would love to get him under oath, and we're attempting to do that, but we've had somewhat less than stellar cooperation. That's our position, Your Honor. Thank you.
All right, thank you. Mr. Albright?
Thank you, Your Honor. Again, just to be clear, our office nor our co-counsel represent Brandon Davis. We represent G&G Capital, and we represent Mr. Gentilozzi. Injunctive relief, as the court recognizes, is extraordinary relief. We're in a court of equity, and a court of equity does not help those who does not help themselves, Your Honor. And the plaintiff comes before this court with an unrecorded, questionable document that is at best a possible right to purchase this property. It is not a land contract under any stretch of the imagination. It is a possible right to purchase with unfulfilled contingencies, missing terms, and with an entity that was not even in existence at the time this alleged agreement was entered into. That is the best case scenario for the plaintiff that comes before the court seeking the extraordinary relief of or extraordinary remedy of injunctive relief. That is contrasted by the defendant who acquired the property through a title company. They have a warranty deed that was promptly recorded. And with regard to the closing and with regard to the relevance of the closing, I have one document I'd like to share with the court. I did email this to Attorney Giddings earlier in the day, so he has seen it and is aware of it. I'm going to share the screen. And there we go. What I'm showing to Your Honor is a copy of the purchaser's statement with regard to the December 16th, 2020 transaction under which G&G Capital acquired its warranty deed. I highlight for the court that I hope the court can see it because the participants are blocking my share, but what this document shows is that it was Mr. Gentilozzi that was required to pay the summer and winter real estate taxes for the year 2019. He was required to pay the summer and winter taxes for the year 2020. He was also required to pay $530 for a trash removal invoice that had been put against the property by the city of Lansing because of the condition of the property. And he ended up having to tender a total sum of $70,027.08 to close this transaction. Now, the summer taxes for 19 and the winter taxes for 20 and 20 are highlighted for the court because those are items that would be contrary. The payment of those taxes by Mr. G&G Capital are contrary to the alleged land contract that Mr. Haddad says has been in place since 2018. I'm going to quit sharing that screen, Your Honor. I'm also going to highlight for the court that it's my understanding that since G&G Capital acquired the property in December 2020, the utilities are in the name of G&G Capital. Again, evidence of acts of ownership and inconsistent with the idea that the status quo is that Mr. Haddad has rights and should be in the property. Now, Your Honor, I'll come back to the issue of the gambling issue in a minute. You know, the court is well acquainted with the four factors that the court has to analyze to determine if injunctive relief should be granted. And, you know, there's a fatal flaw with regard to the request by the plaintiff. And I know the court is not addressing the request for summary disposition. I respect that and understand that. But I've cited to the court and we've shown to the court that in order to do quiet title action, you have to have an actual interest in the real estate. The fatal flaw in the plaintiff's claims and the reason why injunctive relief should not be granted is that he has no interest in the real estate. At best, he has a possible right to purchase the real estate, but he has no necessary interest in the real estate, and therefore he has absolutely no likelihood of success with regard to his overall claims. Now, in citing that, in taking that position, Your Honor, I did cite to the court the case of Johnson Family Limited Partnership versus White Pine Wireless, found at 281 Mishap 364. And that case, in fact, cites the case of Oshkosh Township versus City of Kalamazoo 77 Mishap 33. In preparing for the oral argument, I took another look at the Oshkosh Township case, and I just want to read a couple of things that the court in Oshkosh said. One of the things they said, Your Honor, on page 38 is an offer to sell land does not create an interest in that land. And they cite for that proposition Board of Control of Eastern Michigan University versus Burgess, 45 Mishap 183. They also say that the interest attaches only when the condition is performed, citing Guston versus Union School District of Bay City, 94 Mishap 502. So in terms of analyzing the request for injunctive relief, the lack of an actual interest in the real estate is fatal and is why the TRO should be dissolved and no preliminary injunctive relief should be granted. Case law makes clear that the plaintiffs have no present interest in the real estate, and if they have no present in the real estate, they cannot seek to have the court enjoin or have the court grant injunctive relief because there is no likelihood of success. Now, Your Honor, the other item, one of the other items that was mentioned in my brief is the issue of irreparable harm. Assuming the document that they've attached to their complaint is a valid document, and assuming it is what it is, and that is a possible right to purchase this property, what Mr. Haddad has is a possible contract right against Brandon Davis. And if he has a contract right against Brandon Davis, his relief is monetary. It's not irreparable harm, as alleged by the plaintiff. There is no irreparable harm. Any wrongs, any claims of the plaintiff can be and is addressed by way of monetary relief, which again mitigates against the court issuing any injunctive relief whatsoever. Lastly, Your Honor, there is the issue of public interest and public safety. We have advised the court that the city of Lansing has attempted to declare this property as a fire risk in its present condition. And that is mainly because of the equipment and items and storage use that the plaintiff is currently making use of the property. And so if this injunction is granted and the defendant, the plaintiff is allowed to remain in possession of the property, then the public is at risk for this potential fire hazard. Now, with regard to his personal property, Your Honor, we couldn't be more crystal clear. We would be absolutely pleased as punch if the court would set a date which would allow Mr. Haddad to remove his personal property items from this building. We want that to happen. We want that to happen in the worst way. And if the court would set a date and it fails to remove items of personal property, then we would like to have the ability to dispose of the property and reserve the right to charge back the cost against Mr. Haddad in that regard. In terms of the issue of the claim that this can't be a valid transaction because there was adequate consideration, I've shown the court the closing statement that totaled over $70,000, most of which, well, probably one-third of which was actually cash laid out. But where my fellow counsel is wrong on this issue of not being able to be lawful consideration, he's wrong and he's against the wrong law. If the court looks at the Gaming Control and Revenue Act found at MCL 432.202, there is a section defines what is gambling and gambling games. And while it does mention card games, there's a very, very significant exception from what is a gambling game under the laws of the state of Michigan. And I'll just read the exception. And this is found at MCL 432.202, item B as in Victor. And the exception is, this is what is not a gambling game, but does not include games played with cards in private homes or in residences in which no person makes money for operating the game except as a player. So private poker games and losses at private poker games are not illegal gambling as asserted by Judge Giddings. They are explicitly exempt from that definition under MCL 432.202. In short, Your Honor, we have a situation where the defendants in this matter did everything by the book. They went through a title agent. They paid consideration. They have a recorded warranty deed, which was properly recorded. Their interest is superior in the property to that of the plaintiff. We ask that the TRO be dissolved. We ask that no injunctive relief be provided. I would also ask that if the court does dissolve the TRO and the temporary restraining order, it was recently brought to my attention that the plaintiff has recorded or may have been recorded a less pendant on the Register of Deeds. So if the court does decline to grant injunctive relief, it does dissolve the TRO, we would also request that the court include that the plaintiffs remove that less pendant from the title immediately, because that would be an improper cloud on the title if the court does deny the injunctive relief sought by the plaintiffs.
All right,
Court,
thank
has
you.
any questions about my position? I'd be happy to answer any questions.
I don't believe I have any. I will give Mr. Giddings a chance for a rebuttal if he wants it.
Just a couple of things, Your Honor. That act that he just cited has nothing to do with a private game at home that's covered by the criminal laws, the section I cited. This has to do with other gaming activities in the state. It has nothing whatever to do with this. And I've got to say, with regard to the fire hazard, my client has been working with the city of Lansing. We've agreed to work with the city of Lansing. There is no fire hazard there. As a matter of fact, we've attempted to arrange meetings with the fire marshal and Greg Venker, assistant city attorney. We had one meeting set, I believe June 8th or thereabout. And our client was ready to go. We had a time set, and apparently there was some difficulty getting Mr. Gentilozzi there to participate in this review of the premises, evaluation of the safety standards. And the city has now gotten back, and they want us to go ahead and set up another meeting to arrange for the fire marshal and persons who would be knowledgeable to deal with this issue of safety. There is no issue of safety. But again, he's right. If you make an offer to purchase, that does not give you an interest in the real estate. This is not an offer to purchase. When you look at what happened here, they signed a contract and it has certain conditions. Those conditions do not come into play unless the purchaser, Tony Haddad, gives certain notices. And those conditions were present for his benefit. And so that contract is a contract enforceable for his benefit. And he paid thousands of dollars. This is not an offer. In what situation would one pay $50,000 plus for an offer? I mean, that's patently unrealistic. And it didn't happen here. I mean, he's been paying, and those text messages are clear from Brandon Davis. I mean, there's no discussion of any offer in there. He says the contract, I got your, $10,000, you've paid this and one thing and another. And so clearly this is an agreement, and there doesn't even have to be an agreement. Under Zach and Gray and Michigan law, well-established exception to the statute of frauds. If you have partial performance of a contract, the other aspects, the formalities are not necessarily required. And I didn't write it. The Supreme Court said it a long time ago, by my count, 70 years ago, and they've said it repeatedly. That's an exception to it. So there's a contract, our guy has paid money, and he's got an affidavit which stands undisputed, that Gentilozzi knew about his interest, came to him with a purchaser. You don't ordinarily go to somebody with a purchaser when you know that there's some offer floating around. You do that because you acknowledge and recognize their legal interest in that property. And it would be much less disruptive. Let's let sleeping dogs lie, if you will. Probably a bad label there. And let's see what happens. And let's find out what this defaulting Brandon Davis has to say. We'd love to get Gentilozzi under oath. We don't have him under oath. And let him say. And by the way, 2/3 of that amount paid in the exhibit that Mr. Albright presented to you was not out of pocket. 2/3 of that was this purported gambling debt, which we will show was in fact a gambling debt. The lion's share with a payment of taxes, and anybody who had the property would have to pay the taxes. Tony would have to pay the taxes. He's prepared to pay the taxes. So all of that was done. He couldn't get the title and couldn't get the title in the fashion that he got it without paying those things, because the title company never would have issued, and he couldn't get his warranty deed without taking care of those. So those were a step in his creating this picture of legitimacy, which we submit is not legitimate in the slightest. Thank you, Your Honor.
I have a question for you, Mr. Giddings, because now that the fire code case has been brought up, and I know the defendants, and
I'm
when
sorry.
I say defendant, I have
I'm
a
sorry,
question.
Go
I
ahead,
have a
I'm sorry.
question. Now that the fire code case has been brought up, and I know that it was attached by the defendants, and by the defendants, I'm referring to G&G and Gentilozzi. Now, I understand that Davis is not a defendant here, a represented defendant here. But now that they've attached that and it's been brought up today, when the plaintiff filed their papers asking for a TRO and asking me to enjoin not only the sale of the real property, but also to protect the personal property contained in that, why didn't the plaintiff show me and tell me that there was an order from the district judge that directly pertained to the disposition of that personal property?
Well, we didn't do that, Your Honor, because we weren't sure that it was entirely pertinent. But the other point is that judge has opined that the order is to be set aside, both those orders. And
Yeah,
that occurred
after I
before.
issued a TRO.
I'm sorry?
After I issued a TRO.
Not true. She opined that would be set aside. It would be back on, I'd have to go back and look, but 8th or 9th. It was before that request for TRO. She said both those orders are set aside. We've had some dispute. I sent a proposed order around to counsel, Mr. Hafke, and he said he didn't remember it was that way. And I sent it to the assistant city attorney to vacate, in fact, the order, to reflect what the court had in fact order. But she
Okay.
had before said these orders are both set aside.
If the personal property, though, was subject to proceedings in another court, whether the order was in place or not, if they were subject to another court proceeding, wouldn't the plaintiff tell me that when they're asking me to issue a TRO pertaining to that property? Because after all, the court rule does not allow a TRO to issue to stay a case in another court. And in effect, that's what I ended up doing with the TRO, because I didn't know that the property was subject to the fire code case proceedings.
I guess I can't disagree with you there, except,
Okay.
like I say, I mean, it's subject in the sense that the case was there, but the judge made clear that the order was to be set aside. I mean, I guess I could have recited that history and said that, but it's
Right,
in the
because
sense.
the court rule says that you can't even grant a TRO that would state proceedings in another action if the relief requested could be sought in the other pending action. So even if it's not currently sought, or there's not a current order, if it could be sought, which this makes total sense, then you can't get a TRO. So I think that would have been really relevant, but I heard your answer, so I'll just go on. I'm ready to make a ruling. And my,
may I? Well, I'm sorry. Go ahead, Your Honor.
My ruling comes almost entirely from the court rules, and specifically that's 3.310, the rule on injunctions. And although it's not really necessary today, since it was brought up in a briefing, I do want to address some of the procedural arguments surrounding the issuance of the TRO, because there's been quite a bit of back and forth about that. First of all, nobody asked me for a hearing on the TRO. TROs are only issued under the court rules without a hearing, because it has to be shown either that if you have a hearing, there would be damage or loss resulting from the delay, or if you give notice of the hearing, it will cause adverse action. So there's no provision in the court rules for a TRO with a hearing. If you could have a hearing, you wouldn't need a TRO, because you could do a motion for a preliminary injunction and do it with the required hearing. But when one of those factors is present, that there'll be damage or loss from delay in giving notice, or notice of hearing will cause adverse action, then that obviates the need for a hearing, and it paves the way for issuance of a temporary restraining order. And the other thing that I wanted to mention is that is true, and temporary restraining orders are granted without a hearing, even when there is a known attorney representing the adverse party. And I'll direct you to, under that 3.310 rule, subparagraph B1. So clearly the rule contemplates that there could be an attorney, but there is no notice. And again, for the reasons that I've indicated. So the last point I'd like to make is that I issued the TRO on the grounds that a delay to give notice would cause harm or damage. So I found the necessary requirements for a TRO without a hearing and without notice, even though there was a known opposing counsel. And I hand wrote that in the TRO myself, because the plaintiff omitted that requirement, and that it is a requirement that it must be in the order, see subsection B2 under that rule. But I just wanted to summarize those points, that there was no procedural error in this case in issuing the TRO. Second, I would note that there really is no need to consider the defendant's motion to dissolve the TRO, because it's already dissolved. Again, see B3 under the injunction court rule. We had a show cause scheduled for June 16th after the TRO was issued on June 7th. It was adjourned by a stipulation, but the stipulation only adjourned the hearing. It was a stipulation and an order to adjourn the hearing. There's nothing in the order that was submitted that the defendant was consenting to an extension of the TRO. And the plaintiff, if they're adjourning the hearing, they need to obtain that consent and put it in the order along with the reason for the extension. And that's expressly required by the court rule. If that's not there, the TRO automatically expired. It expired on June 14th. Nevertheless, the plaintiff bears the burden of showing that injunctive relief is warranted, and I am concluding that the plaintiff has not met that burden. Again, I wrote on the TRO that was submitted, and I modified it to cover only the plaintiff's personal property and not any real property. And that's because the plaintiff stated in their motion for a TRO that it was buying the property on a land contract. Well, first of all, no land contract was attached to the motion requesting a TRO. So I had nothing even to verify that. Second, the defendants have now attached a purchase agreement, but that wasn't attached to anything that the plaintiff submitted. But even if they were attached, either one of those things, whatever may exist, all that's been shown to me, and I agree with the defendants in this regard, is that at best, the plaintiffs had an agreement to purchase the property. If we want to call it a land contract, then fine, we can call it a land contract, but that doesn't give the plaintiffs an ownership interest in the property. They've complained that they've paid thousands and thousands of dollars, and if that is the case, then if the property were disposed of in some way, they might be entitled to damages and consideration, but it would be money damages. So they've certainly failed to show irreparable harm, because money damages are not irreparable harm. And they have failed to convince the court that they have any ownership interest in this property that would justify this court restraining or enjoining the owner of the property from disposing of it or selling of it or disposing of it in any way. So the plaintiff has not shown irreparable injury. The plaintiff hasn't showed any entitlement to a preliminary injunction. I enjoined the disposition of the plaintiff's personal property, but now I learn that that personal property is the subject of the fire code case. So that causes concern because, as I've already indicated, you can't have a preliminary injunction that would act to stay proceedings in another action pending in another court if the relief requested could be sought in the other pending action. Now, I will note that the other pending action, if this case caption is correct, is not the same parties. So it's the city of Lansing versus Brandon Davis. So, I'll grant you that, and that maybe that means that there's some entitlement to relief here because I have different parties that I'm dealing with here. But I would certainly not grant a preliminary injunction with respect to the real property. With respect to the personal property, I would grant very limited relief, and that is going to be along the lines requested by the defendants in their prayer for relief. And that is that I would, I guess we can call it restrain and enjoin the defendants from disposing of or removing the personal property items at the subject property for a period of 14 days only, to give the plaintiffs an opportunity to remove their personal property items. Anything that's not removed by the plaintiffs within 14 days of this ruling will be deemed to be abandoned by the plaintiffs, and defendants may dispose of that, and that includes of the authority to throw it out, put it in the trash, or anything that isn't been timely removed by the plaintiffs. And as I've indicated, further relief in the form of an injunction as to the real property is not warranted. And Mr. Albright, if you would prepare an order that reflects that and submit it, please.
Yes, Your Honor. Can I ask for clarification on one point, please? In light of the court's ruling and in light of the recent knowledge that we learned that a less pendants might be recorded against the property, can I include a provision in that order that requires the plaintiff to withdraw or remove that less pendant?
Well, I'm not so sure about that because I haven't reached the merits of any of the claims except for injunctive relief. And so I'm not satisfied that there is, no claim that would justify the Liz pendants that's been put on the property.
Thank you, Your Honor. I just sought clarification on that point.
Yeah.
The fact that was recent information. I understand.
Yes, okay. Great, thank you. And then as of tomorrow, the court's no longer taking e-filings. And they were never e-filings. They were filings by email. But just for your information, as of tomorrow, there's an order that the 30th Circuit Court isn't taking that anymore. So anything you submit has to be in mail or delivery.
May I ask one question, Your Honor? Because I understood you to say, if I might, that that there was an adequate remedy at law, or we had not shown that there was an inadequate remedy at law, but there are numerous cases that say when you have real estate, that's not a proper standard. I cited that at page 13 of my response. There's,
I think my ruling
I
speaks for
can't read.
itself.
What's that?
My ruling
sorry?
speaks for itself. My ruling speaks
Okay.
for itself.
Thank you, Your Honor.
Thank you.
Thank you, Your Honor.
Thank you, Your Honor.
Just to let you know, I called DOC and they're